My name is Stephanie Mata. I'm an associate attorney here at the law offices of Beltran Brito Casimir. To my right is Gil Brito, managing partner here at the firm. Today we're going to be talking about Valentine's Day, very special day. We're going to be talking about marriage-based immigration. So first things first, everyone's heard about it to a general extent. Today we're going to go into some details, and we're going to look at who's petitioner and who's beneficiary and what are the benefits.
Sure. So let's talk a little bit about United States citizen petitioning a spouse versus a lawful permanent resident petitioning a spouse. Okay, so when the United States citizen petitions a spouse, they're going to go ahead and there's a lot of factors to determine, Stephanie, right? So it's going to be number one, is the person physically present in the United States or not? Okay, number one. Number two, is it a United States citizen spouse? Is it a lawful permanent resident that's actually doing the petition? There's potential children to take into consideration. There's different time frames to take into consideration. Let's talk specifically about one of the most common ones, which is going to be a United States citizen petitioning their spouse. Now, if their spouse happens to be here in the United States, you could do what's called, obviously, let's just say that the individual entered lawfully into the United States, was inspected into the United States, and is here legally. It could be a situation where they're here on a work visa, they could be here as students, they could potentially have been here as a tourist. And what happens there is the individual will then go ahead and potentially file a concurrent filing. That includes an I-130 petition, which is it's going to be the family-based petition, concurrently with an I-45 green card application, and requesting work authorization and potentially travel authorization if it applies as well. Okay, so this is a normal process if the individual is here. It could all be done at one time. It is considered an immediate relative category. That person is immediately a visa number is immediately available for that individual. What does that mean? A visa number? There's this thing called the visa bulletin. There's different family-based categories. People could go ahead and review the visa bulletin, and they'll see that since there's different categories, there's different wait times. There's only what's called almost like a visa quota system, correct? So the visa quota system creates certain delays. Not in the immediate relative category. The immediate relative category, there's always a visa number available. The person's always able to apply. If they're here in the U.S., what does that mean? That means they could apply for the change of status application at the same time as the spousal petition.
So what if the petitioner is a longtime permanent resident, a green card holder?
Okay, that's a good one, because that's a frequent situation where it's what's called a preference category. There is a wait time. There's actually, so since it's a quota system, there's so many applicants, you get what's called retrogression. You get a backlog going on. Okay, so what happens there? It's really important, and it's just something that people need to be made aware of. They think just because they've married a lawful permanent resident, my lawful permanent resident spouse can now petition for me. They can. Does that confer immediate status to them? It does not. And that's an important point. If you find yourself currently in the United States, you need to have some sort of parallel legal status in the U.S., not just waiting for not just having that pending I-130 petition. That will not confer legal status to you. That's a very essential point. If you're here as a student, you need to continue your student status. If you're here on a work visa, you're on an H-1B, you're on an L-1, whatever it might be, you need to continue being in lawful status throughout the time that I-130 petition is approved and the visa number is available in that category. That category for an LPR is called Category 2A. You can check out the visa bulletin and kind of see where the dates are. For people to have an idea, you're looking at almost a 2-year wait right now for an LPR petition. That, of course, is if the person's in the United States. If the person's abroad, if it's a United States citizen, if it's an LPR, filing the petition, whomever is filing that petition, you initially start that process with what's called the I-130 petition. You file the I-130 petition. That's going to, depending on the category, if it's the United States citizen or the LPR, that's going to be anywhere between a 1 to 2 year process to receive the immigrant visa. Okay, whenever we obtain a green card via the U.S. consulate, they call it the immigrant visa. The U.S. consulate is conferring a visa to you. They don't actually give you the green card, but those two terms are synonymous within immigration law. So the immigrant visa will be issued upon entry to the U.S. with that immigrant visa. Then the individual is going to go ahead and receive the actual green card.
So what about individuals who have ESTA or visa waiver program, which is a lot of clients, a lot of potentially you guys out there?
Okay, so you have, you don't have a tourist visa necessarily. You come into the U.S. with ESTA. You're one of the countries in the ESTA program, maybe in Europe, maybe in South America, and what does that mean? I come in visa waiver. You do not require a visa to enter the United States as a tourist, and you're married to a United States citizen. You can change your status lawfully in the United States from ESTA to green card. Okay, now that is probably the only thing you can do on ESTA. You can't switch over obviously to an H-1B, you can't switch over to a student, you can't extend your tourist status, you can't do any of these things, but you can if you're married to a United States citizen. If a couple different immediate relative categories, right? If I'm married to a United States citizen, if I have children that are 21 years of age, born in the United States, and if I could also, if my child is over 21 and lives in the United States and a United States citizen, they could also. That's all the immediate relative category. Those individuals can go from ESTA to green card in the U.S. And actually can do the process here.
So let's talk about the actual process. What sort of documents is immigration looking for? What sort of documents do you need to provide?
If we're going the marriage route, right, we need the marriage certificate, obviously. This is a really interesting point, and I hear this all the time from clients. They've been married before, and they say they're divorced, or I'm no longer with that person. Or I was married in Colombia. I'm not married in the United States, am I? Yes, you are married. The United States is going to recognize that is a valid marriage as long as it was a valid marriage in the jurisdiction that you were married. So in that particular case, you're now coming to marry a United States citizen or a lawful permanent resident. Are you actually divorced? Number one. So that's the first thing we'd like to take a look at. And it is actually a lawful divorce in the sense where you're in the same country as that individual at the time that the divorce was filed. There's significant case law to that effect, and USCIS has actually denied significant cases because they do not recognize that was a true divorce in that individual's country. It's kind of a disaster for a family. You might have to go ahead and actually get a divorce, get remarried, refile the entire petition. So number one, are you actually married? Okay, and then you're going to go ahead and be married. The individual needs to also demonstrate, obviously, their lawful status in the United States if they're here in the U.S. and the process is being done here in the U.S. Something important let's talk about this distinction. The petitioner and the beneficiary. So the petitioner in this case is going to be the United States citizen. The beneficiary is going to be the foreign national individual that's here in the U.S. being the beneficiary of this petition. Now, the petitioner needs to demonstrate typically that they're able to financially support this person in the United States. So a very important point is this thing called the affidavit of support. So affidavit of support, it's one of the kind of the common questions I receive from clients, and the affidavit of support basically is a contract that you're signing with the U.S. government that says you are becoming financially responsible for that person before one of two things happens. They become United States citizens, then you're no longer financially responsible for them. Or as green card holders, they've already put in what's considered 40 quarters or 10 years of actual, like paying taxes in the U.S. and Social Security, this type of thing. So I basically tell people it's on the ballpark, basically a 10-year 10-year contract, and for 10 years you have that obligation that you're responsible for that person. What happens if the person isn't financially able to do that, and I don't meet what's called the poverty guidelines. So you need to meet what's considered 125% of the poverty guidelines. This doesn't apply to service men and women where they can petition for their spouses if it's 100%. Just for you to have an idea, if it's one or two people that I'm petitioning, are you around the $25,000 mark, for example, on yearly income? If you're not, and you're not able to produce that or demonstrate that you're producing that with a tax return, with an employment verification letter, with pay stubs, and you're not able to produce that, you could obtain what's called a joint sponsor. So this could be any green card holder, any United States citizen that's working and that is able to demonstrate that they're also going to go ahead and do this affidavit of support with this individual and be able to be financially responsible for them in the U.S. Okay, so that's one of the major components to this entire process is the financial aspect, because you need to always show that this individual is not going to become a public charge in the United States. Okay, so we'll keep going. Go ahead.
And the joint sponsor does have to provide sort of the same documentation you were mentioning,
They
which
do.
is the tax returns.
Tax return, pay stubs, verification, letter of employment. Are they actually green card holders or are they United States citizens? It does not matter if the individual is a family member, it's a friend. It just needs to be basically a U.S. person.
And for marriage-based cases, in these types of cases, we do have interviews. So what is the interview process like? When does it take place? Where does it take place?
Yeah, if it's here in the U.S., let's go through a typical time frame that we're seeing right now. There's a lot of delays. This is just kind of the new norm for U.S. immigration law. There's more delays. You're filing, the person's in the U.S. lawfully. They're filing a concurrent petition. You're looking. The general time frame is going to be you file the case. Generally within 5 months right now, at the 5-month mark, the work authorization card is being approved. The travel authorization, if they apply for one, is being approved. After that, you're looking at generally within a year, we're seeing interviews. We've actually been seeing a lot of cases lately that have been taking over 18 months in the U.S. To have the actual interview here in the U.S.
And what's the interview like? What's the process? What are they asking you?
Yeah, I mean, mainly, again, it's going to be, people hear probably horror stories of that interview. I think that interview is really just going to be a verification of information, reviewing documentation, reviewing that everything that was stated in the petition is accurate, all the documentation that's being provided is accurate. And listen, they're going to ask you about your marriage, very likely. I mean, they want to know where
That's a bona fide marriage.
Yeah,
right?
of course. I mean, it's like, did you actually get into this relationship for love and affection, or is this for immigration benefits? And they're gonna and they're very skilled at asking questions, and you need to know your life together with this individual, and without getting into specific questions, you really need to know kind of everything about each other's life. And this is what I tell clients all the time. This is just an administrative process that should result definitely in a successful petition if everything's done properly.
So in the case of a beneficiary who they got married to the U.S. citizen or the longtime permanent resident less than 2 years before receiving their green card, what do they receive?
Right. So that's a great point. So at the time of the immigration interview, even if it's abroad, even if it's here in the U.S., if you have been married for less than 2 years at the time of that interview, you're going to obtain your permanent green card, but it's called a conditional green card. So it's the same lawful permanent resident status as a full green card, but it is going to be for 2 years versus 10 years. Why? They want you to check in over the next 2 years, specifically 90 days before your the 2-year green card expires. They want you to go ahead and file something called the I-751. I-751 petition is where you are removing the conditions of your green card. What do you have to show then? You might not have to go to another interview. You need to show tax returns. You need to show bank accounts, insurance. You need to potentially show affidavits. You need to show that you continue to be married to that individual. And it should be an administrative process, which is going to take roughly about a year or so, and then you're going to go ahead and obtain your 10-year green card.
So what if at that point you are divorced now from your spouse?
Excuse me. This is a good one. Okay, so we see this a lot. I mean, things just don't work out in life. I mean, that's you're off. Okay, things didn't work out in life, and you have filed for divorce. If the divorce is pending and your green card's about to expire and you file the I-751, they may deny the I-751 because you need to. It doesn't mean you're not eligible to renew your green card. You are, but you have to request what's called the divorce waiver. What does that imply? You must be already divorced when you file that I-751, number one. Number two, you need to show at the time that you were married to this individual post green card, you were really married. And the documentation is, we had tax returns, we had a bank account together, we had a life together, we have photos, we have affidavits from people, and there needs to be, kind of a reason as to why we had this divorce. So it's okay to have a divorce, but it's a little bit of a different process. Typically, a divorce waiver applicant will require an additional interview. They go by themselves to that interview, and post that interview, they will typically receive their green card as well.
And a lot of clients always have this question. Once the beneficiary has their green card, how long do they have to wait to become a U.S. citizen? Okay,
so if you're married to a United States citizen, okay, and you've been a green card holder for 3 years, you're able to already apply for U.S. citizenship. Okay. If you are no longer married to that United States citizen, you need to wait for 5 years. And then after 5 years, technically, you could do it 90 days before your 5 years and 90 days before your 3 years, and you could apply for it. A common question or a common situation I encounter is the individual has filed to remove the conditions on their green card. So they've been a green card holder approximately, let's just say 2.5 years or 3 years, because you have the I-751 still pending. But can they apply for U.S. citizenship? Technically they can. And we've actually had clients do that. And what happens is they've accelerated the I-751 process. But you still need to have the conditions removed before the naturalization officer can approve your U.S. citizenship.
So to that point, the time that you were on the conditional green card, that does count towards this sort of 3 or 5 year time.
100%. 100% of the time counts. Yeah. Yeah. Always when we're trying to determine how long you've been a green card holder, you can simply look at your actual green card. It's going to say something to the effect of residence since date. That is the official date when you became a green card holder for various reasons, not specifically this category, but in some other categories. For example, Cuban Adjustment Act category, they actually give you your residence since date to be retroactive, potentially to the date that when your spouse obtained their green card as well. So funny enough, in that particular scenario, a lot of people, are in marriages with Cubans and lawful permanent resident Cubans. In that situation, you actually have a green card sometimes that'll go back a few years, and you can apply for U.S. citizenship much faster.
Okay, perfect. So I'm going to check if we have any questions, and if not, I believe this is going to conclude our marriage-based interview and our marriage-based what we're talking about here, which is marriage-based on immigration-based marriage.
Important. Kids. Let's just talk kids real quick. So I go ahead and get married. My United States citizen husband, can he petition my children from a different marriage? Can he petition? Let's call them the stepchildren. Can he petition the stepchildren? He can petition the stepchildren. She can petition the stepchildren if the relationship happened prior to that child turning 18 years of age. Okay, as long as that relationship happened before that, and the marriage, okay, the actual marriage, then that parent can also apply. Those children are considered have the same benefits as if it was his own children, and he would be petitioning for them. Okay, so that's just an important point of note. We talked about significantly doing this process within the United States. If we were doing the process abroad, you will be attending a consular interview before a U.S. consulate officer. It's going to be a similar type of interview. Sometimes the spouse needs to travel to that interview. Sometimes the spouse does not. Many times the spouse is living with the individual in that country. This is an interesting point, and we actually saw this recently in a case. I'll bring it up, and I think it's a valid point. For affidavit of support individuals, and you need to demonstrate that you are you're living in the U.S. and you're working in the United States. And so what about the scenario where I live with my spouse abroad? Okay, so we're living abroad, but now I want to go back to the U.S. and I want to bring my family with me to the U.S. Or let's just say just my spouse to the U.S. But I'm living with them. Haven't been working in the U.S. for years, haven't been living in the U.S. for years, and I'm petitioning for this individual. We're going to want to discuss that. That's a very particular case, and we're going to want to discuss it with that client. But again, I see it frequently, and we need to discuss what are those ties to the U.S. I mean, the idea of family-based immigration is family reunification. Okay, so do you need family reunification if you're actually living with the person? Just an interesting policy point, and it's a case that needs to be documented a little bit differently. Okay.
Right. Okay, so thank you for being with us. If you have any questions, you can contact us at media@beltranbrito.com and all our social media accounts, which is at Beltran-Brito LLP. You can stick around for the 12:30, which is our Spanish broadcast.
Thank you.
Thank you.